Good morning. Will the February 20th, 2015 Legislative Committee meeting of the Contractors State License Board come to order? I'm Joan Hancock, Committee Chair. Since this meeting is being conducted live teleconference, I'd like to remember board members to please state your name prior to making a comment. I believe there's only one board member doing the teleconference today. And in addition, any item requiring a vote will require a roll call vote. Only board members who are members of the committee may sit at the table. I wasn't going to say that. We're all here. We have a quorum, and so because we have a quorum, only those members on the committee are allowed to participate in this discussion. So we're going to take a roll call for the quorum, and Laura will call the roll.
Joan Hancock.
Here.
Augie Beltran.
Here.
Linda Clifford.
Here.
Paul Schifino.
Here.
Nancy Springer.
Here.
Paul, are there any members of the public with you at your location at this time?
Yes, there is.
Would you like to introduce yourself? Could you speak a little louder?
My name is Bill Oltamoto.
Good morning. All right. So we'll move to agenda item B, the public comment section. This item is, I'm sorry? That's all right.
That's my fault.
We'll introduce ourselves. Start with you, Kurt.
Good morning, everybody. Kurt Hepler, Supervising Attorney, Department of Consumer Affairs.
Christy Shields, Attorney 3 with the Department of Consumer Affairs, newly assigned counsel to the Contractors State License Board. I've been with the department for 15 years, and before that I was in private practice for about 5 years working in civil and criminal litigation. Thank you.
David Foe, Chief of Enforcement.
Nancy Springer, Board Member. Cindy Christensen, Registrar.
Joan Hancock, Board Member.
Laura Zuniga, Chief of Legislation.
Linda Clifford, Board Member.
Augie Beltran, Board Member.
Karen Robinson, Chief of Licensing.
So now, members of the public, we'll go out to you and start at this corner and go through the room.
Board Member. Ed Lang, Board Member. Dave Diaz, Board Member. Kevin Albanese, Board Member. Michael Jaminsky, Quality Assurance Analyst. Greg Shutter, Board Member. Greg Armstrong, National Electrical Contractors Association. Murray Marcus, California Landscape Contractors Association.
Beverly Carr, Politico Group.
G.V. Ayers, formerly with Senate DMP Committee, now retired and with Tunnel Rivers Consulting.
Licensing Division.
Jamie Plantorn Swift.
Hugh Henderson, Peace Officer Investigator, Sacramento.
Shelby Northman, Special Investigations Unit, OC.
Deidre Green, Peace Officer, Special Investigations Unit, Norwalk.
Eugenia Canchola, Peace Officer, Special Investigations Unit, Norwalk.
Shelby Brooks, Peace Officer, Special Investigations Unit, Valencia.
John Anderson, Peace Officer, SIU, out of San Bernardino.
Peter Cowan, Peace Officer, Special Investigation Unit out of San Francisco.
Christina Duff, Deputy Chief of Enforcement.
John Bruce, Supervisor, Special Investigation Unit.
All right, good morning and welcome. Moving to agenda item B, this is the public comment section. This item is provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot take any items or take action on any items not listed on the agenda. CSLB welcomes public comment on any item on the agenda, and it is the CSLB's intent to ask for public comment prior to committee taking action on any agenda item. If for some reason we forget to ask for public comment on an agenda item, member of the public desiring to comment should raise their hand, and they will be recognized. We will be limiting public comment to 5 minutes per individual. Any members of the public wish to comment in advance of our agenda items? And our public member teleconferencing, is there any item you wish to comment on prior to our agenda items? Can you speak up, please?
No comments at this time.
Thank you. All right, so we'll move to agenda item C, and Chief of Legislation Laura Zuniga will give an update on the Sunset Review.
I just have a brief update on this item. The board's sunset review hearing is scheduled for March 18th. The hearing starts at 9 in the morning. I think we're the third board on the agenda. Each board has an hour for its presentation, and then members of the public are invited to attend, as well as stakeholders. The Senate Business and Professions Committee will ask us some follow-up questions and issue a background paper before the hearing, but they haven't yet released that, so we've just had follow-up questions, response to the report, but nothing significant to report at this time. It'll be at the Capitol in room 4202.
Any board members have any comments?
Hi, this is Paul Shapiro. You mentioned that there's a paper going to be issued prior to that meeting.
Yes.
Is that something that's going to be circulated to the board members?
Yes, it will, and we'll also send it out to our distribution list.
Okay,
so
great.
It should be released, hopefully in the next week, because it'll have some follow-up questions that we need to respond to.
Okay, thank you.
Nancy Springer. You said March 18th, but it's the 16th, Monday the 16th?
That's a board meeting.
The board meeting, okay, sorry.
Any member of the public wishing to comment? All right, thank you. We'll move to agenda item D, and this is the update on the consideration of the 2015 legislative proposals. We took up these proposals at our last full board meeting, and we're going to go through them individually, and Laura is going to take a moment for the benefit of the public to explain what happened at the last board meeting on each proposal and any differences between then and now, what you're going to see, what you see in the packet right now. Thank you, Laura. So agenda item D1 is the amendment to Business and Professions Code 7011.4, Notice to Appear Authority.
This proposal would allow our enforcement representatives to issue a written notice to appear for failure to have workers' compensation insurance. It would be an additional citation issued at a sting for those who are generally contracting unlicensed. They also often don't have workers' compensation insurance. So this would allow us to include this in the written notice to appear. The board approved this language as amended at the board meeting. The language as amended is what's in print in the packet now. So I don't think we need any further action on this item. It's just an update on the status.
All right, so nothing, I'm sorry, Ms. Zuniga, nothing's changed?
Nothing has changed.
Go ahead, Augie.
So the blue is what's being submitted? Is that what that is?
The blue,
The
I
blue
believe, is an
paper.
explanation of the proposal. Is their analysis?
It is, in mine it's white, so it's the first page. The back of it is the language in the packet.
Okay.
Should be on page 2 of 2.
Oh, there it is. Okay. Thank you.
The underlined section is what's different, right, Laura?
Correct.
Okay. And also, we have an author for that bill?
We do, Senator Monning.
And
This is Paul Shapiro. Laura, just a quick question. If we could just, for the simple guy on the phone, we already have an NTA ability for unlicensed activity. This is adding to that an NTA, notice to appear, for failure to carry workers' comp insurance. And remind me, this is a notice to appear before a state judge, or this is an administrative law judge? Just remind me where we sit in our legal process.
This would be part of the case that's sent to a district attorney for them to take further action.
Got it. Okay. Okay. So meaning, so that would be under the state process, or just is the DA? That'd be the city process.
Right, so like a county or superior court, not by an administrative law judge.
Okay. Got it. Got it. Okay. Thank you.
Dave Vogt.
Just a little clarification. The reason we need this authority is when we're conducting an undercover sting operation, we'll have an unlicensed contractor bring employees to that sting. And so when we issue the written notice to appear in criminal court, we need to be able to include the workers' compensation insurance violation on that written notice to appear, so that when we file that complaint with the DA, both of those charges are filed at the same time, and the defendant will show in court for both of those charges at the same day, on the same date.
One of the things in the analysis also explained that there are other agencies that, while they have the power to issue a notice to appear, they don't have the power to file a criminal charge with the DA. Could you explain that and those two agencies?
CSLB has direct authority to address the need for a license and for a workers' compensation policy. We share that authority with the Division of Labor Standards Enforcement. DLSE has enhanced authority to issue civil penalties that are quite significant. What they can do is they can assess penalties based on every day of employment that worker was present without workers' comp, and so they will generally use an administrative remedy rather than the criminal courts. At the Contractors Board, we work very closely with DAs. They provide our backup at sting operations, and they're funded by workers' compensation insurance grants. And so we really need this authority to continue to be effective with our undercover operations. It's not that another law enforcement or regulatory agency couldn't address a workers' comp violation. It's just that the CSLB is uniquely qualified to address it at sting operations.
Linda Clifford.
Linda Clifford, board member. My only question is, I don't remember that we wanted, I totally agree that we need it and support it, but I thought it was the existence of the workman's comp insurance. We're saying ensuring payment of the workman's comp insurance, and I don't know, I mean, at the moment in time where you find somebody with workers and no workman's comp insurance, you pretty much have done that. If what you have to do is go a further step and find out whether they paid it, and that maybe there's some administrative mess up on their on their insurance side. That doesn't seem like a good thing.
Well, yeah, just to clarify what we're asking for, there are employers that have a workers' compensation insurance policy. They may have obtained it and they're not reporting payroll or under-reporting their payroll. That would be considered premium insurance fraud. This has nothing to do with that. Premium insurance fraud is a felony. This is for misdemeanors, and it only applies when someone has a worker and does not have a policy at all. So you have to. That's one of the elements to support the violation. They must have an employee, and they cannot have a policy.
Right. So wouldn't it be broader if we said existence as opposed to payment? I mean, I want to give you I again support this. I want to give you the broadest possible way to apply this. If they can't hand you a policy certificate, they're done. You don't have to. Doesn't matter whether they say no, I paid. It's like no policy, citation, right, or NTA.
Yeah, we're certainly in favor of having broader authority. Absolutely. I would mention though that the language, it mirrors Labor Code 3700.5, and so we use the same language that already exists.
So before we move to Kurt, I just want to comment that is the same language that the full board approved. Yeah, exactly. I have the packet here. And now to Laura. Sorry.
I think we can continue to look at that, though, at the staff level as the bill goes through. If we need to revise the language and to further the intent of the proposal the board approved, we can do that and then bring it back to the board later on.
And Kurt. State your name again.
Kurt Hepler, supervising attorney. This is probably a little bit of my fault in inartful drafting. So I think the real issue was, I think when the board talked about it last time, I think board member Clifford's exactly right. I think we were talking about one, in some respects, you don't have it. correct me if I'm wrong, it's like, Mr. Fote, it's like you're supposed to have it and you don't. I'm not quite sure, probably of my naivete getting down to payment. I think the issue is you're supposed to have a policy and you don't have that policy. So to the extent the language is really directed at for failure to carry the required, failure to carry the required, well, if I'm having a stroke, I apologize, failure to carry the required workers' compensation insurance, that's the real target of the legislative proposal.
Any other comments? Yes.
So you could change the language to say, "and failure to carry workers' compensation insurance as required by," if that's what your true intent is. If it's broader than that, then maybe we'll stick with what you have. But if it's 3700.5 states the failure to secure the payment of compensation as required by this article by one who knew or basically should have known of the obligation. So if you're worried about clarity, that's an option to maybe modify it as Mr. Hepler's indicated, to say failure to carry or failure to secure workers' compensation insurance.
So at this time,
sorry, Linda Clifford, board member, I'm totally supportive, so if we don't make a change, I just want the broadest thing for enforcement.
all right, our registrar suggested that we allow staff to work with legal to come up with the correct verbiage to be resubmitted to the board at the March 16th meeting. Is that okay with everybody?
Yes.
How about you, Paul? All right, we're not taking an official vote on this. We're in abeyance, and we're going to tweak it. And we did give staff permission to tweak the language. It was really subject to language, and you could, follow up with that, Linda, if you want, with staff. Okay. All right. Any members of the public want to comment on this issue? Sure. So please state your name. Turn your mic on.
Richard Markison for WICA and PHCC and ACTA. And to Mr. Fote's point, I think it's important that you use this authority in a situation, because as I understand it, and welcome any comments from your staff, you could have a policy in place, and getting to the premium fraud question, but if you're not reporting payroll and paying the premiums, there is no coverage for those employees. And so I think it's important to this authority that you not only have the policy in place, but the premiums are being paid for the employees, and thus they're being covered. So I welcome looking at the language later, but I think it's important that you cover both of those eventualities where there is no policy or there has been a policy that's been issued but no premiums have been paid, and thus there is no coverage available.
And I think this gentleman's absolutely right. I could have I'm a contractor. I could have a policy in existence and not be paying my premiums. I could show somebody a certificate, but that doesn't mean I've paid the premiums.
Just for clarification, this is Christy Shields. The Labor Code says they have to secure payment. So to me, that just showing the proof of insurance would not be sufficient to show that they have to actually prove they secured the payment. So I think if the language reflects that they failed to secure, a valid or current payment or carry workers' compensation insurance, that should get you where you need to be.
Yeah, I think the word valid, again, this is Paul Shapino again, but I think using a word like valid or something along those lines is wordsmithing, but I do think we need to encompass the existence of a certificate doesn't necessarily mean you have a valid policy.
Kurt Hepler.
Thanks again. I think this is exactly right. I think it's a rough analogy would be to if you let your automobile insurance lapse, but you mail in your little card in order to effectuate DMV registration. It's somewhat the same phenomenon. So I think Board Member Shafino is exactly right. I think with the board's indulgence, I think we should leave a little room for staff and legal to come up with a solution to the problem. I think knowing sort of the parameters that Mr. Vogt has suggested along with the gentleman who spoke publicly.
So is there any reason why we can't have that before the next board meeting?
No.
Great. All right. Any other public comments? All right, thank you. Let's move to the next agenda item. D2. This is the amendment to Business and Professions Code, Section 7028.6, the authority to issue citations, collection of additional information. And prior to Laura giving a synopsis of this, I believe it was back in September we met in committee, and all of us really worked very hard to come up with something that was acceptable. This is a hard issue, and so it's still in flux, and I think it's really important to I don't believe there are any changes that have been made in terms of the language here, but there are some other issues that have come up since our last board meeting in December following the committee meeting. So would you explain that?
Sure. Excuse me. This is Laura Zuniga. So this proposal would allow the staff to collect Social Security numbers from unlicensed individuals when they're cited. It would be voluntary on the part of the individual whether they want to provide the number, but it would allow us to try to seek collection of citations against those who are unlicensed by using their Social Security number to participate in the Franchise Tax Board's Intercept program. We did have a lot of discussion about this proposal at the committee meeting and at the board, and it was approved by the board. I did go ahead and submit this to an author's office to find a member to carry it in the legislature. The senator's office I submitted it to rejected the proposal and had real concerns about going into this area because the collection of Social Security numbers is a sensitive issue, so that concern led Dave Fote and I to talk about it further, and we decided not to see what other things we could do outside of legislation at this point because of the concern that was expressed. And then also related to the issue that Joan was speaking of, since the last board meeting, we've had another issue arise with use of Social Security numbers, the sharing of Social Security numbers of licensees between state agencies for enforcement purposes. So I think we're going to need to seek legislation on that issue, which will come before the board at the next meeting. But I think staff felt that was a more pressing issue to address, and because they both involved the use of Social Security numbers, felt it was better to concentrate on that issue for this year.
Do you want to respond on comments that we heard from industry yesterday at the industry meeting at the Capitol? Was there anything in addition? I'm trying to...
I don't think there was anything specific to this. I think on the other issue of the sharing of Social Security numbers, that I think in general industry felt that was important for enforcement efforts, but it would also be very difficult or challenging to get legislation approved because it's such a sensitive subject, so that we needed to be very careful in how we draft the language and how we proceed with that.
So that's where we are right now. Board members, any comments?
You know, Laura, I did have a question. Just remind me why we didn't just go with driver's license, copy of a driver's license or something like that instead of Social Security numbers?
The tax agencies require the use of a Social Security number as an identifier.
The tax agencies. Well, what does that, if our goal is to make sure that an unlicensed contractor that is cited pays the fine, why would a tax agency, what does that have to do with the tax agency?
So the reason we need the Social Security number for those that are unlicensed is we have a very low collection rate from these people because we don't have much to hold over them since they don't have a license. So there's the Franchise Tax Board has what's called an Intercept program where they can withhold from tax refunds, any outstanding fines or penalties that are owed to other state agencies. So if we could participate in that program, we could potentially collect more of the citations in that manner, but we would need to use a Social Security number to transmit the information to Franchise Tax Board for them to track the individual and participate in that program.
Now, if we issue a citation and they send in a check, that check comes to the CSLB, right?
Yes.
Okay, and if we have their driver's license and they don't send in a check to the CSLB, we would have their address theoretically on a driver's license. We could send them a nasty letter, right?
Yes.
Does that get us someplace? Just throwing it out there for chat.
We collect some of the citations, but I think our collection rate on these is maybe about 20%. I'm going to let...
Isn't the issue that the Franchise Tax Board requires a social security number? I mean, I think that's the answer.
Yeah,
David?
but my point is that if we can't, sorry, this is Paul again. My point is that if we're going to get resistance on the Social Security number, can we get to the same place or at least somewhere along the process of having a better chance of collecting on the citations through a driver's license number? It's really just I'm just looking at it as if we can't get door number one, which we prefer, the Social Security number through the system, then would door number two help? And if the answer is no, then the answer is no.
So Dave Fote is going to comment, Paul.
Yeah, just a quick comment. We are in the process of reestablishing a contract with a collection agency, and that'll be helpful in collecting these unpaid fines. And the driver's license is sufficient for working with the collection agency. It's just that if we're going to partner with Franchise Tax Board on the offset program, we do have to have the Social Security number.
This is Paul again. So Dave, so we're already getting a copy of a driver's license, and now we're going to pursue working with a collection agency in addition?
Absolutely, yes, that is correct.
Okay, got it. All right, so therefore I didn't change much of anything. Okay.
Augie Beltran, I got a question.
Augie Beltran.
So they have a heartache with Social Security, but how did they feel about the taxpayer ID number and the federal employer ID number? Did they have a heartache about that?
I think it was mostly about the Social Security number was the concern.
So could we still float this with those other two?
Excuse me. Oh, that certainly could be an option. I think we included those because legislation that was chapter last year that allows people to now seek licensure without a Social Security number using one of those alternate numbers. So, yeah, that's certainly an option we could
I think that gives us a little bit more room to move into this type of stuff.
This is Cindy Christensen. I think the biggest issue amongst the legislature and in just the current environment is the issue of privacy. And with us collecting Social Security numbers and what we're going to do with that information, and I believe that was the information we collected back when Laura was shopping around for an author. Is that correct, Laura? It's a big issue right now. So whether it's a tax ID number or Social Security number, that we're just being met with resistance there.
Linda
Clifford, board member. So if we were willing to take off the Social Security number along with this new collection agency effort, we could at least move both of these initiatives forward, measure their success against, a period of time, right, and re-look at this in the future. I mean, with this huge Anthem thing that just came out, 80 million people, stuff out there, I mean, you can understand why people are saying, we don't want you to collect it, and then you're going to transmit it. It's going to go up to the moon and back, and somebody's going to catch it, right? So you kind of get that. So maybe we could make some progress by taking that out and doing the collection agency thing.
So one of the things that came up, I think, in committee and at the last board meeting was that, well, first of all, we had abstentions in terms of the vote that was taken at the board meeting in December. But one of the issues that came up in both meetings was the fact that, individuals that are applying for a license have to submit their Social Security number. And so I think, the same issue kind of prevails, but what was brought to our attention is what do we do with that information and whether or not we would do anything different than we already do with people that we license where we already have their Social Security information. And I know you elaborated on that, David, and maybe you could explain what we do at this point.
Well, the reason we need the Social Security number is so that we can share information with the Franchise Tax Board. And so the licensees are providing the Social Security number. In fact, it's on the original application for licensure that they're asked for the Social Security number for the purpose of sharing it with the Franchise Tax Board. So we use it to collect unpaid fines. We use it as, in some cases, an identifier of an employer that's in the underground economy. It's, again, used for identifying employers and taxpayers. If I just add one thing, though, I want to make real clear that we do consider it very confidential, and we take great steps to protect that information. So the Social Security number is only shared with Franchise Tax Board and the Employment Development Department. And that's something we're going to have to look at down the road, our ability to continue to share that with the Employment Development Department. But if you have a chance to look at the Activities and Accomplishment Report for last year, what you're going to see is we were instrumental in helping the state collect well more than $10 million in unpaid tax liability, and that's in large part because of our ability to share the Social Security number with Franchise Tax Board and EDD.
Go ahead, Linda.
Linda Clifford, board member. So we're already doing this. People are already putting it, we're already doing everything in here. The only thing this is saying is that we could ask somebody and they could voluntarily give us the information. But if they voluntarily refuse to give us the information, we either have it already because they did at some point in time actually file an application and go through the process, or we don't have it and we're not, this is strictly a voluntary kind of thing,
Absolutely.
Right?
We're only asking for the ability to share information that's voluntarily provided to us, to CSLB, with the Franchise Tax Board. It doesn't provide any authority to make it mandatory. It's just that when we're out conducting a sting or running a lead or conducting a sweep, we do ask for identification of the individuals that are present, and one of the identifiers they can provide a Social Security number. Again, totally voluntary.
One of the things I want to mention, and maybe pairing with what you're about to say, hopefully, is we worked really hard on the language, and I think it would be really good for you to restate what language we came up with at the last meeting, or maybe it's in this packet right now.
This is Laura Zuniga. Yeah, the language in the packet is what we came up with as a result of discussion at the Legislative Committee meeting in November. So prior to that, it was more strongly worded and made it seem as if it was mandatory for individuals to provide this information to the board. So we did revise it after that meeting due to concerns expressed by the committee members to make it clear that it's voluntary on the part of the unlicensed individual as to whether or not they want to provide it to the board, but that if they did, we could go ahead and use it for collection purposes.
Just read the pertinent part on, is that on one-on-one, page 1 of 1?
Yes. So it was amending Business and Professions Code Section 7028.6, Subdivision B. The registrar is authorized to collect and record a Social Security number or taxpayer identification number from a person that is cited. The Social Security number or taxpayer identification number shall be used only for the purposes of ensuring payment of a civil penalty.
Okay, let me interrupt you just for a second, because the language we had at the committee meeting was the individual shall submit their Social Security number, and that's what we were all upset about. And so went back and the language was tweaked to say that the CSLB was authorized to collect information, which doesn't make it mandatory, and it's basically like what David is saying. They can volunteer it or not. So that's where we are. And do you have any comments, Registrar?
I just have one comment. I mean, we'll be more than happy to pursue legislation and find an author should the committee and board request, well, actually the committee, because what do we have, a week, Laura, to get an author for this? But I think, if we could just pursue other options other than legislation this year, as Board Member Clifford had suggested, of just trying to use the driver's license, working with the collection agency, and seeing how effective that is without this type of legislation, I would just suggest that we move forward that way. But like I said, we'd be more than happy to try and get an author.
So the only thing left on the table was Augie's comment about the TIN number.
Yeah, but it sounds like either way, they're not going to buy it. So why spend some legislative capital? Let's just do the experiment, see how that rolls, and look at this again next year.
Is everybody in agreement with that? Paul?
This is Paul Schifino. I totally agree. Let's not waste the political capital on a dead-end street.
Well, okay, what is the right procedure right now, since we can't table something that we've already voted on?
So we're sort of stuck with, as I understand it, there's really an issue. We're stuck on the fact that we don't really have a lot of legislative acceptance of our idea, but the board has at least suggested it pushed forward. So in all due respect to everybody and the risk of being the most unpopular guy in the room, I would suggest a motion that we just simply not, that the committee recommend to the board that it not proceed with this legislative proposal. And that would, I think that would send a clear path.
Linda Clifford, board member, so moved.
Augie Beltran, second.
Further commentary, I'm going to ask Laura to give me some commentary here. She'd rather not. All right. Any other members of the board want to express concerns at this time? And if not, members of the public? No, no longer. Okay. So I'm going to ask Kurt, if you will, to restate the motion for all of us.
My pleasure, Board Member Hancock. It would be my suggestion that the committee recommend to the full board that it not proceed with this legislative proposal at this time.
Bear in mind, we do not have an author anyway, so all those in favor? I'm sorry, we need a roll call because we are in teleconferencing. So start with Paul Schifino.
Yes.
Joan Hancock.
Yes.
Augie Beltran.
Aye.
Linda Clifford.
Aye.
Nancy Springer.
Aye.
All right, motion carries. All right. We'll move to agenda item D3, amendment to Business and Professions Code Section 7083, notification by licensees of change in recorded information. This carried at our last meeting. I don't mean to take your script. Go.
No, it's fine. This was a minor change that was recommended by one of the enforcement staff. There's a conflict in the general B&P provisions, which apply to all of the department's boards, and CSLB's law and the time frame for a licensee to report a change in their address. So we have the board approved an amendment to CSLB's provision so that our time frame will prevail, and this was accepted by the Senate Business and Professions Committee, so it'll be included in one of the omnibus bills introduced this year.
So that's the report on that. No further action needed. We'll move to, unless there's any comment from the public or other board members. Well, we'll start with board members. Any other comment here? And the public, any comment on D3? All right, thank you. We'll move to agenda item D4, amendment to add Business and Professions Code Section 7103.5, effect of a disciplinary action by Division of Labor Standards Enforcement. And Laura, please follow through.
So this proposal was brought up at the board meeting in December, and the board sent it back to the legislative committee for further work and appointed 2 members to work on the issue. It was Augie Beltran and Kevin Albanese. So staff worked with the 2 board members over the interim period to try to address concerns that were raised at the December meeting. Staff doesn't feel that we were successful in addressing all of the concerns that were raised, and then as we worked on the issue further, felt that it needed additional work and that there were actions that we could take without statutory authority that we should pursue first before pursuing a legislative change. And so the analysis in your board packet identifies those on page 2 as the staff recommendation, and we outline 4 different activities that we think staff should take first before pursuing the statutory change.
This is Paul Schifino. Madam Chair, Laura, how does the staff document, or how does the staff ensure that a protocol is followed first before resorting to the proposed language and the modification, the disciplinary action?
I'm sorry, are you asking how we would document that we would take these actions that are outlined in this analysis?
Yeah, what I'm looking for is that from what you just explained, my understanding is that staff's going to go through steps 1, 2, 3, and 4 kind of before they get to the disciplinary action of the new code 7103.5. Is that a correct way of restating what you said?
Correct.
Okay, so how does the CSLB staff document for their own internal protocol? Is there a book that says, here's what the staff does in the event of this? How is this enforced internally at the CSLB?
Well, I think I'll leave that to Dave Fote to explain how the Enforcement Division would document that. I think all of these issues have been brought to David's attention in enforcement, so I think this is something that he tracks.
Yeah, just for context, we receive dozens of civil wage and penalty assessments, perhaps more than 100 in the last year, and we review those to determine the most egregious ones. And last year we did write administrative actions for those that generally had an unpaid civil wage and penalty assessment exceeding $100,000, and it related to a repeat offender. Now, what prompted the legislation is those legal actions were returned by the Attorney General's office. Would it be possible for me to run through these 4 steps just to maybe add some?
I think that's a great idea.
Some clarification to it.
Please.
So, we had more than 10 accusations that were returned, and we took a look at the civil wage and penalty assessments that we had on hand, and I've met with Karen Robinson, and we're exploring the opportunity to use our outstanding liability suspension program for those that are unpaid. If it's relatively minor, not a repeat offender, no action has been taken in the past, no action will be taken in the future. But if money is owed to workers or on civil penalties, we're going to explore suspending the license by automation of law per existing statute. And hopefully we'll be able to do that. Another area we have to look at is revising the application, because what's very troubling is you'll have a public works contractor that agrees they owe their workers more than $100,000, perhaps $500,000, and they file bankruptcy. They don't disclose it on a new application for license. We want to make sure that they have to disclose a civil penalty or an action taken by another state agency. Again, something I'm working with Karen on, and hopefully we can make that amendment to the citation, because that'll go a long way to achieving our goal of making sure that the awarding authorities, awarding agencies, can use pre-qualification to hire the most responsible bidder. Another problem we've had is that the labor commissioner, they're aware of contractors that are, quite frankly, engaged in wage theft. That's what this is. They're receiving public dollars. They're not paying their workers. We want to sit down with the labor commissioner, and we want to go over the MOU and make sure that we're aware early on of a problem. Because one of the identifiers of a problem public works contractor is they're not providing certified payroll. And so just based on that, with existing law, we can take an action. But again, this whole thing, everything we're talking about is focused on going after the truly bad actors. And then we've got 2 accusations that are currently moving forward. These were 2 that were initially returned because we didn't have the authority to be alleging a civil wage and penalty assessment violation. However, what we did find is that there were fraudulent activity that could be alleged, and again, they didn't file the certified payroll timely. So as far as us capturing our statistics, we will absolutely report back to the board on how many licenses were suspended for outstanding liability and how many actions we took and what was the outcome of those actions. How did the administrative law judge rule when we came forward alleging the prior violations I discussed, the not reporting of the certified payroll, and perhaps fraudulent activity by issuing fraudulent checks? Did we receive the desired discipline? If we did, there's no need for legislation. If we did not, we may want to revisit this.
Well, thank you, David.
Augie Beltran. So we suffered through this, and I would have rather seen the original language go through, because I'm always a fan of giving staff the tools that they need. But I also understand that people need to possibly see a pattern before they accept new language and change. I think the language as proposed originally would have given staff an awesome tool in order to enforce or do enforcements out there. But this is a good tool. We can use it for next year and show the entire board why this language is necessary.
So at our December board meeting, we did not vote for or against this. We voted, and I selected you and Kevin Albanese, and thank you very much for the two of you for serving on this advisory board. I don't know if your work is done.
Hopefully not, because I want to see this happen.
Yeah, so I know you can't say a word out there in the gallery, but thank you, Kevin. So at this time, we have nothing to vote on, and we're just going to move to the next agenda item unless...
I move that we accept staff recommendation.
Second.
All right, any other comments from the board? The committee, I'm
Question
sorry.
On the question, do we need to recommend to the full board that we follow staff recommendation, or do we need to just say follow staff recommendation? Okay,
Yeah, but the
so amended to recommend to the full board.
Is the second okay with that amendment?
Second, okay.
All right, any public, further board committee member comments? Public member comments? All right, we'll take a roll call vote.
Joan Hancock,
Aye.
Augie Beltran,
Aye.
Linda Clifford,
Aye.
Paul Shafino,
Aye.
Nancy Springer.
Aye.
D5.
Okay.
Agenda item D5, amendment to Business and Professions Code, Section 7137, the fee schedule.
So this proposal was presented at the December board meeting, and the board approved the language, but it did have some blanks in the language where we didn't have the fee amounts set in the language. Staff completed a workload analysis to determine what the appropriate fee level should be. So the language is now complete. So would like the committee to approve the final language for this proposal.
So moved. Augie Beltran.
Do we have a second?
Linda Clifford, second.
Comments from committee? The only comment I have is that this was another issue that was discussed, and we had some feedback from industry yesterday. And do you have anything you want to share?
So I have not found an author for this proposal yet. It's not so popular, the fees, but I am working on this proposal and the next one that's on the agenda, the home improvement salesperson registration. I think as we discussed earlier, we have a week before the deadline, so I'm still optimistic that we'll be successful.
The biggest issue being the two fees that were the bigger jump, the adding a classification and expediting the
yes, I
process
would say,
of getting a license.
I think in general, members of the legislature were just uneasy about fees. I did get one specific comment about the expedite fee, that there was a concern about establishing a two-tier process for processing of applications, and so it was rejected for that reason by one office.
Linda Clifford?
And I would like to, I wanted to get a second so we could get the discussion going, but there are a couple of places in here where it feels a little bit steep, and I do think that this priority processing is I think it's problematic because it does have a tendency to create an impression of, well, if I can pay a little bit more, I can go to the head of the line. And so, I'm wondering if we might be willing to put the rest of these forward without that expedited processing. And Karen, maybe you want to speak to that. But, perception is reality for a lot of people, and I think that's probably what the perception is.
Sure, and this was something that was really being spearheaded by members of the industry. We have a current expedite process, but there's certain criteria you have to meet. They were looking for something more along the lines of what Secretary of State does. You pay the additional fee and you get priority processing. So I do understand the concerns, but again, this was something that industry was looking for. The other fees, we have been charging nothing for officer change and a very, woefully deficient amount for add clause and replacing the qualifier, since the work is essentially the same as the other applications. So those were something that we put forward just to make things a little more even.
The first fee is that you're concerned about, Linda, is the expediting fee and how it appears.
That's the one I have the most hard.
Yeah, and so yesterday when we were at this meeting, industry asked about that very question, and they asked you, how quickly is it expedited compared to, standard applications? Why don't you explain that a little bit?
Well, currently our processing times are pretty low, so it's not a huge jump, but it does give them priority processing for looking at the application, scheduling the exam, then when it comes to issuance. So you could cut a week or two off of the application. Many of the services that help applicants want this so that they can get their applications put through quicker. But it's not, right now, it's not a huge thing. Now, in the past, when we were weeks and weeks behind in processing applications, it would make a significant difference.
Well, and Karen, too, I think it's important yesterday, too, that you indicated that it will not delay the individuals that have filed a regular application.
Correct. We would have technicians who would be identified for processing these apps. It would not slow down the current process for existing applications.
Are these additional technicians, or are we borrowing them from other staff?
No, we believe we can do it within our existing resources.
Linda?
Linda Clifford, board member. The real delay that we're suffering right now is the fingerprinting, and we have no control over that, correct? I mean, that's being done by the federal government, and so that is delaying everybody's application to a certain extent, right, for whatever time they are taking, right?
It can. We have some applications that are on delay from Department of Justice. For whatever reason, the fingerprints haven't been cleared. For those individuals who have no criminal history, their prints are good, they're going through in about 48 hours. So that's not a big deal. But yes, and that's why we chose to call it priority processing and to put in there, this doesn't mean that, it still means you have to clear fingerprinting, you still have to meet all of the other requirements. It just means we'll pull your app ahead of time and review it and let you know what you need to do. It all, for exam apps, we have no control over how quickly an applicant can pass an exam. So we're not putting days on it. We're just saying you will get priority handling of your application.
Who spearheaded this idea?
I was first approached by Phil Vermeulen about this, and then I've gotten other...
I explain who that person is and what they do and
I don't know
why
how to
that's
explain
important.
Phil. He handles application. He does governmental work. We get several expedite requests from Phil. We get several from Rick Pierce with Basic Craft.
He's industry.
Yes.
He's an industry.
There's probably 10 groups. It mostly comes from the licensed services, the requests for expedites. But Phil was the one who approached me first.
Question from Nancy, and then Laura, please.
Well, I actually have a comment. So the way I'm reading this and the way I look at it is these additional fees, the request for additional fees, really will be able to pay for the services for these additional staffers so that you can keep the regular applications on a continuation of going and staying in line, but also helps to provide the additional staff to give this expedited service. So you're not taking away from the ones that are still in line.
Correct.
Explain additional staff.
Well, we may redirect certain staff to just work on the priority processing applications. We're not talking additional staff adding to the staff, but rather redirecting existing staff to work on these applications.
So, Laura, would you like to comment?
I was only going to mention, because Linda Clifford mentioned that it was a significant increase in fees for the ones that we're raising. And it is, but that is a ceiling that's going to be established in statute. We are going to need to, by regulation, establish the actual fee amount we would charge. And I think based on the workload analysis, I want to say it's closer to about $215.
Are we talking just about the expedite fee?
No, that's
No,
not.
all of them.
It's the other fees, not the expedite fee.
I mean, that's why I did the second, because I
So
Correct.
for
When
the-
we do the regulation process, we'll have to demonstrate what the actual cost is to the board to process these applications.
So for the benefit of the public, at our last board meeting, we voted on this issue in concept without those fees being elaborated, and this is, what we're here to decide now. And as we have a motion and a second on the table, and with regard to your concern, Linda, about the appearance of the expedite fee, I think at this point, and before a vote and asking for public comment, that if you want to do something about that, you can ask to amend that or table.
Linda Clifford. board
Or
member.
with deference
Okay.
to our legal, our
I think
new
that the
legal
motion
people.
should be voted on the way it is unless the author's willing to amend and the second's willing to support that amendment to the motion. So you can vote the motion up or down. If it passes, it's moot. If
Let's
it's
hear the
voted down,
amendment
then
first.
you can do a new
If
new
you're gonna-
motion.
You're not going to amend it, are you?
No, I was actually going to say, I just wanted to bring it up as a perception issue.
Oh, okay.
It's voluntary. Nobody has to walk in here and pay a priority processing. And
Right.
as long as it's voluntary, then it's an option. People
Correct.
can come in and talk to them and say, well, wait a second, how long is it normally taking? And if she says 2 weeks, they can say, well, I don't want to pay $300 or $200 or $150, whatever it ends up being ultimately with their justification for, for 2 weeks. I'm happy. That's good. Karen's group is really on top of it now, and so I'm not sure this is even necessary, but I'm happy with the motion. I'd leave it the way it is.
Well, that's good to hear. As a point of order, I am curious, pardon my ignorance, but if there is a motion on the table, does a member have the ability, power, within the rules of whatever Bagley, Keene, Roberts Rules of Order to table a motion prior to a vote being taken on an original motion?
Well, once it's out, once it's before the body, I think you have to proceed. I think the maker of the motion can always, withdraw it, see where we go from there. But I think the issue is, there was some sort of at least conceptual idea to delete the priority processing. And I think that's what Christy would do. That's what I was talking about. I think that Ms. Clifford came around and said, no, I don't want to do that. So I think that's where we are. So I think we have a motion and a second to move ahead with this as proposed here. So, but I think the maker of a motion can always step back and say, whoops, no harm, no foul, I don't wish to proceed. So.
Okay, thank you for that. I think that answered my
Augie
question,
Beltran?
but I'm not sure. Augie.
As long as we're on motion 101, you don't need to make a second just for discussion.
Oh, okay.
I feel at this time it's important to ask the professor, Paul Schaffino, do you have any input?
I think we came full circle to where I wanted to be. I do think there might be a market advantage having expedited fees. situations where emergencies come up, and I think it's a good thing to keep, and so I'm in support of the motion the way it stands.
Okay, we'll take a vote on that, but not until we hear from the public if they wish to comment. Yes, Mr. Marks. Please restate your name.
Richard Markison for WICA, PHCC, and ACTA. Any of you who've flown in the last couple of years know that there are many options now for expedited service, at least 4 that I'm aware of. The one thing that I might suggest to the board that you consider is possibly waiving the expedited fee for disabled veteran business enterprises, because certainly I'm very sensitive to the perception issue, and this is something that you might consider doing with the legislation to address some of that perception. There are a number of bills going through the legislature right now on DVBE, and that's just an option for your consideration. Thank you.
So I think Laura's going to respond to that.
There are general BMP provisions to waive or to expedite applications for active duty military members and those that are that meet certain criteria. So I think and partners of active duty military. So those would continue to be expedited without a fee. The disabled veteran business enterprise, I don't think we would have the ability under the language the way it's written now to additionally authorize, but that's certainly something the board could consider, or potentially something for the whole department.
Any other comments from the public? All right, so let's take a roll call vote.
And this is to approve the language that's in the packet today. Joan Hancock.
Aye.
Augie Beltran.
Aye.
Linda Clifford.
Aye.
Paul Shafino.
Aye.
Nancy Springer.
Aye.
All right, this motion carries. Moving on to...
I'd just like to ask a question, since that was raised. If the code was changed to provide for DVBE, it would automatically apply, wouldn't it, to our, as it's updated, wouldn't it apply so that if there was that waiving or expedited, would it?
So if there was legislation enacted that would provide for expedited processing for disabled veteran business enterprise, similar to the other provisions that exist, the way that the language is being drafted, it would allow for those to continue to be expedited without paying the additional fee.
Okay.
I think it would really be good if the minutes for the next board meeting reflect those comments and the suggestion from the public member that came and presented that. Okay, let's move to agenda item D6, Amendment to Business Professions Code 71. I'm not even going to read, there's so many numbers. Home improvement, salesperson registration.
Okay. At the December board meeting, the board approved the concept of going forward with this legislative proposal, but there was no language prepared at the meeting. So since that time, staff has drafted the language that is in the packet. So we would like the committee's approval to proceed with this language. This proposal would allow a home improvement salesperson to register with the board and then work for multiple contractors rather than needing to re-register for each employer.
So once again, it seemed like we had some feedback from industry yesterday on this, and also we do not at this time have an author for this bill, but we're hoping to have it tag along with 7011.4, wasn't that?
So this is one that the industry has asked for. Specifically, the California Solar Energy Industries Association is really interested in this proposal, as well as other groups that are impacted with home improvement salespeople. When I was seeking an author for this proposal, I packaged it with our fee proposal because I didn't think I could sell the fees on their own, and I haven't been able to sell the combined package yet either. So at this point, I have also split them up to see if I can find an author for just the home improvement salesperson piece, if I cannot find someone to take on the full package. I don't think that will be a problem. It's a very good proposal. It's beneficial to the industry. It will be a little bit of a workload savings for the board, but there's really no downside.
Any further discussion, committee members first? And Kurt, do you have something to add?
Ms. Zuniga and I have talked. I think one of the things that was omitted from this or needs to be included, I think conceptually going forward, is the concept this would be done electronically, and that the HIS person and the employer or whatever could submit the required forms and notifications electronically, and that would stand in for the paper process, because I understand this is an issue of expediency. You have a transitory workload population here.
Laura.
So we did prepare the language originally. It didn't address the electronic issue, but it is, as Mr. Hepler mentioned, something that would be important for the industry and will be helpful for the board. So he submitted some draft language, which was very helpful. It's not in the version that went to Legislative Council to be drafted because of the timing issue, but if this bill goes forward, we would seek to add that in as soon as we could. So it would be the authority to accept electronic signatures for this purpose.
All right, any further comment from committee members? Public comment? All right, I'm going to ask for a motion.
So I make a motion to accept this as proposed and to add the electronic signature at the appropriate time. That would be my motion.
Second.
Any further comments? Committee? Public? All right. We'll take a roll call vote.
Jonah Hancock?
Aye.
Augie Beltran?
Aye.
Linda Clifford?
Aye.
Paul Shafino?
Aye.
Nancy Springer?
Aye.
Motion carries, moves to agenda item E, and before I adjourn our committee, I want to thank Laura for your hard work. As always, you are amazing, and staff, and also, again, thank the people that worked on the advisory board and all of the committee members for being here. We're adjourned. You're up, Bob.